5 seconds to go. Start. It add in ignoring that in terms of the mandate of Order 2nd Rule 2 of the Code of Civil Procedure 1908, hereafter called CPC, KIC, in KIC suit first was bound to include the whole claim which it was entitled to make in respect of the cause of action, and if it omitted to sue in respect of or intentionally relinquished any portion of its claim, it could not afterwards sue in respect of the portion so omitted or relinquished. It was argued that being party to the 1995 suit, KIC was aware of its claim ownership over the suit schedule property. Therefore, the omission on KIC's part in claiming relief of declaration of ownership in its earlier suit, that is KIC suit first, which was tagged with the 1995 suit, statutorily barred the subsequent suit, that is KIC suit second, for declaration of title under Order 2nd Rule 2 CPC. Learned Senior Counsel argued that the High Court overlooked that since the grant issued by the Government of Karnataka was held to be nonest by the common judgment of the trial court dated 31st January 1998 in the 1995 suit and KIC suit first, and that such finding was modified by the High Court in RSA number 236 of 1999 to the effect that the grant in favor of Munish is deemed to have been cancelled. KIC lacked locus standi to file a suit for declaration on the basis of such grant. Learned Senior Counsel also drew attention of this court to the High Court's order in RP number 493 of 2005, where it confirmed that the grant as claimed by KIC was deemed to have been cancelled, thereby stripping it of any right to title to the suit schedule property. Learned Senior Counsel relied on the decision of this court, where this court upheld the jurisdiction of trial courts under Order 7 Rule 11 CPC in rejecting frivolous and vexatious suits. Reliance was also placed on Ram Rameshwari Devi and others versus Nirmala Devi and others, where it was held that the trial court ought not to have framed an issue on a point which had been finally determined up to this court, and further held that unless the wrongdoers were denied profit or undue benefit from the frivolous litigation, it would be difficult to control such litigations. Ms. Kiran Suri, learned senior counsel for the respondents herein, urged that KIC suit second was not in abuse of the process of any court of law. Subsequent to the filing of the suit, an application was filed before this court. That application was declined. KIC suit first was a suit for bare injunction, and the title to the suit schedule property was not considered. Therefore, the subsequent suit, that is KIC suit second, seeking title and possession, was not barred. Learned Senior Counsel contended that the civil court had to mandatorily issue summons to the respondents and that maintainability of the suit could only be considered after such issuance when it was contested by the respondents. However, in this case, before issuance of the summons to the respondents, the trial court suo motu passed determination on maintainability of the suit and rejected it as not maintainable. That order was contrary to law. Consequently, the High Court was justified in setting it aside. Miss Suri relied on the judgment of this court in Sudhakar versus P. Reddy to urge that KIC suit first was one for injunction. There was no occasion for KIC to claim ownership or title to the suit schedule property. In these circumstances, KIC suit second, claiming title and possession was maintainable. She also relied on Alka Gupta versus Narendra Kumar Gupta to say that the courts should not summarily reject a plaint on the ground that the judgment in an earlier suit barred the later one. It is apparent from the above facts that the two suits filed earlier, the 1995 suit and KIC suit first, culminated in a decision favorable to the appellants herein as KIC's suit was dismissed. KIC and the other respondents appealed against the decision in the present appellant's suit. That appeal was also dismissed. Stop.